They are. On a level of the federal, state judges have the Alabama Judicial Inquiry Commission that they have to respond to. Federal judges do not respond to the Alabama State Judicial Inquiry Commission, but they do have their own, supposed self-governing bodies. I remember there was that federal judge down in Florida, you know, that the 11th Circuit got after because of some of his what they thought were irregularities, and that's they have their own governing body that can take complaints about federal judges and consider them, and it actually has the ability ultimately of a sanction of removal from.
Now, this wasn't filed at the beginning of the trial that night.
No, because apparently they did not know about it. They didn't know about it until fairly recently, only after the trial was over. And I would say, respectfully to the judge, I mean, I think, you know, it's something that should have been disclosed. And then
talk about that for a moment.
Yeah.
In terms of a judge disclosing information ahead of time before the trial?
Right. In order to preserve the appearance of impartiality, in order to be as fair as you can, you have to disclose any potential conflict you might. I've been in court where judges, state and federal, said, well, you know, I have stock in such and such company. I mean, I have the high regard for Judge Albritton down there, and I mean, I think I remember one time him saying something at the beginning of a trial about, you know, I've got an interest in this or that, and if that's a problem with anybody, just want to let you know, and giving you an opportunity, you know, to consider it and recuse. And other judges on the state level have done things like that, and I think that's a proper way for it to be done. And, you know, the SEC will get yourself, you know, will indict people. I mean, you know, the whole Martha Stewart thing, you know, of course that was insider trading, but they will indict people for not disclosing certain things, you know, and so, I mean, if that kind of high standard of propriety is going to exist on the level of the SEC and other things, then it ought to exist on the level of federal judges. They should not be above the law themselves, especially when they're ruling on such important questions of law.
In a case like this, I can see the need for a disclosure, especially where you have parties that may have financial interest in situations or in businesses and corporations. Does that also apply to judges? Should they also disclose? Would it be important for them to disclose financial information about themselves and, let's say, businesses that they are connected with, where it might have an impact on the case that's before them?
I think they should do it, even if they, deep down in their own heart, feel like it won't have an impact on them. They should do it nonetheless, because it has a lot to do with the confidence level of members of the public. I mean, you know, this particular judge may say, oh, it does not influence me that I have an interest in a company that does business with the FBI or the federal government in other respects, even while the trial's going. That doesn't influence me at all. That's what he may say, and he may believe it. But, you know, the confidence level out there, the people that are before his court, where you got serious issues and your liberty may be restricted for years to come, is not high. That confidence level is very low when you hear that the judge is doing a lot of business with one side of the case. You know.
Okay. Well, now that this motion here has been denied by him, what's the next step?
Well, I think from conversations I've had with Richard Scrushy that they're trying to decide whether for it to be treated on the regular appeal of the 11th Circuit or possibly file a petition for writ of mandamus to the court itself. Of course, if you or to the 11th Circuit, you know, I think maybe procedurally you may have to file it in the court itself or something, and it would probably be denied in the trial court and then on to the 11th Circuit. These are procedural issues that will need to be determined by them, but obviously they're not going to let it loose because it's something that concerns them greatly, and not only, of course, Scrushy, but Siegelman as well, both of them. They were entitled to have the fairest judge that they could possibly have. Or at least a fair judge, and neither one of them feel, I know for solid, and a lot of the folks around them who've observed this case feel that they got a fair trial for a lot of reasons, and one of which is this whole email thing, you know, I mean.
Well, that's another point I wanted to bring out, because I think everyone's heard about the emails that occurred during this trial. No, it may have been during the trial and after, during the deliberation period.
Well, you know, it just defies all reason, and to me, it helps to make their case that this judge was not fair, because he himself, the judge, gave strict instructions to the judge. I mean, I've been in a lot of jury trials.
What are some of those type of instructions that a judge would give to jurors?
You're not to converse even with one another, even privately, about the case until you go in to deliberate the case. I mean, under strict instructions not to, because the evidence is supposed to be heard only what's in the trial court in front of you. Not supposed to consider something that you might have heard from somebody else here or might have heard there.
And why is that important?
Well, if you want to have a fair trial, you got to limit it. I mean, the judges has rulings to limit the evidence, keeps things out all the time that might unduly prejudice or be unfair as a matter of evidence, or he lets things in. He has very carefully weigh the evidence, the standards. But when you're letting things in, you know, via somebody else's email, I mean, as I understand it, there were 2 Auburn professors on the jury who were emailing each other back and forth about things. And, you know, they may be bright guys, but, I mean, and probably were leaders, I would gather, on the jury with their kind of intelligence levels. But any one of them could pull out something from here or something from there and, you know, and influence. And